Hello and welcome to the 25th Annual George Mason Law Review Antitrust Symposium, celebrating 25 years of antitrust. My name is Carly Fei and I am the Symposium editor of the George Mason Law Review. This event is brought to you by the George Mason Law Review and the Global Antitrust Institute, and is sponsored by Freshfields and CRA. Thank you for joining our panel, Competition in China and the Pacific Region. Our moderator is Professor Tad Lipsky, Director of the Competition Advocacy Program at the Global Antitrust Institute, and Adjunct Professor of Law at George Mason University, Antonin Scalia Law School. Professor Lipsky?
Welcome, everybody. Welcome back to the next session of the 25th Annual George Mason Law Review Antitrust Symposium. My name is Tad Lipsky, and this panel concerns competition in China and the Pacific region. We have a spectacularly qualified group of panelists here. I am just going to give them the very briefest of introductions in the order in which they will be presenting. I would encourage you to look at their bios and CVs on their various websites, and I understand there's also a bio on the conference website. The qualifications represented on this call are truly spectacular. And first will be Angela Zhang, an assistant professor at Hong Kong University Law School. Second is Reiko Aoki, who is a member of the Japan Fair Trade Commission. Third is Fei Deng, who is a PhD economist who consults for CRAI. And last but not least, my old friend Steve Harris, who has practiced antitrust law over a very long and distinguished career with a number of major international law firms, and now hangs out his own shingle, but still represents a real powerhouse of experience and knowledge on antitrust in Asia. So without further ado, let's get right into it, because actually, considering the firepower we have on this panel, our 1 hour time is quite short. So Angela, if you don't mind, please talk to us about antitrust in China, recent developments, how things are changing, and what kind of influence that's going to have on the world at large.
So a lot has happened in China in the past year, and there are many new legislation that were promulgated. A number of high-profile cases were completed in the tech sector, and there's also very important institutional changes that occur at agency level. So my remark below will focus on these three areas. So let's first talk about the new laws. In February last year, China promulgated a set of important guidelines specifically targeted at online platform business. And this guideline set out a very broad framework for considering antitrust compliance and enforcement in the digital sector. Like the guidelines you see in other jurisdictions, it does put an emphasis on data and algorithms, and recognize that the possession of a lot of data could be a factor for assessing market power, whereas algorithm could be used to facilitate collusion or resale price maintenance. Now, I think most important of all, the guidelines does send a very strong signal that is going to tighten merger control in the tech sector, as previously there was hardly any control, because of the legacy VIE problem. So, and the guidelines now make clear all these deals, those VIE related deals, are no longer exempted. Now, in addition to the guidelines, we are also anticipating an amendment of China's anti-monopoly law. So the anti-monopoly law was formally adopted in 2007. So this will be the first major, quite big change to the national law. And the new amendment is expected to be enacted sometime this year. Now, in the latest draft that we saw in October last year, we did see quite substantive changes of the new law. Now, most importantly, what struck me most is the significant elevation of the sanctions on businesses for the failures to comply with the law, and also significantly bolstered the administrative discretion of the enforcement agency imposing those sanctions. Now, for instance, we talk about jumping just now, right? I mean, currently, the fine that a firm could be imposed for violation of gun jumping could be subject to no more than 500,000 RMB fine. But the draft amendment proposed now a maximum fine of up to 10% of turnover in the previous year if the transaction is ultimately found to be in violation of the law, or even if the transaction is only a procedural, only as a procedural non-compliance of gun jumping, there's no effects on competition, the fine could still amount to RMB $5 million, which is like a tenfold increase. And the agency also has the discretion to multiply the fine by a factor between 2 to 5 if the violation is very severe or the impact extremely large or the consequences particularly serious. So query, what exactly does that mean? And obviously this discretion to multiply the fine does not just apply to gun jumping, but everything else. So, so there is a lot of ambiguity as regard to, how this is really going to work in the future. Now, in addition to this very fluid legislative developments, there are also two really high-profile cases, as you probably have read in the news. The Chinese authority undertook very large abuse of dominance case last year. And the first case was against Alibaba. The case was announced around Christmas Eve in 2020. And then in April last year, a record fine of $2.8 million was imposed. So this case was completed with lightning speed within 4 months. So this is not just unprecedented, in other jurisdictions, it is unprecedented in the history of Chinese antitrust, right? I mean, before, normally an abuse case could take at least a year or two, right, with the Qualcomm case, or like in the Tetra Pak case, it takes 5 years. Now in the Alibaba case, it took 4 months. And the second case was against Meituan. That was announced around April last year and was also concluded within 6 months. And Meituan received a fine of $500 million. So together, these two cases, the amount of fine, these two cases actually account for almost all the fine that was imposed last year. Almost 98% of the fine was about these two cases. Now, the agency, the SAMR, retroactively vetted a lot of the VIE deals, but we just talked about those deals, the fine that they could impose is really tiny. So, so a lot of the companies just rushed to notify the deals, and I heard that's been keeping the agency really busy as well. And with regard to merger, there's a very big case where they imposed quite, some behavioral remedies in the Tencent music deal and also prohibited the merger between Douyu and Huyue, both are owned by Tencent. Now, lastly, let me talk a little bit about institutional change. The antitrust authority at the SAMR, which was created in 2018 after the merger of 3 former antitrust agencies, was elevated late last year from a bureau status to a vice ministerial status. Now, for those of you who have followed Chinese antitrust, this is a huge deal because the agency have faced very severe capacity constraint in the past. It have very few staff, right? It have less than 50 people in Beijing, so unimaginable in other jurisdictions when you think of it. And now, so it is expected to expand to around 100 people in about 2 years, and perhaps 150 people, according to a news report, in 5 years. We will see how it goes, but obviously this is a very big development, and I expect the agency will become much more active in the future. Tad, should I leave it there, or?
Well, let me just prompt you to make some observations. I mean, obviously, this kind of dramatic shift indicates what? Is it that the national government or the state council or other bodies at the most senior levels of the Chinese government consider that antitrust is now a much more important phenomenon than it used to be in China? Or, I mean, you very effectively outlined some very major changes. What's your perspective on why that is, why that happened?
Oh, I recently wrote an article describing exactly what are the driving forces behind this dramatic shift of regulatory approach against Chinese tech firms. It is entitled Agility over Stability. China's great reversal in regulating the platform economy, which is forthcoming with Harvard International Law Review, in which I describe, what exactly has happened. We have a very short panel, and so the story is long. My short answer is it's really complicated, right? I mean, you can't just look at it from a specific angle of a specific person. China's regulatory process is highly complex. It involves the top leaders, the regulators, the firms, as well as the people. So you have at least 4 major actors interacting with each other. And so the situation is very complicated. All I can say, the Ant Group's IPO debacle in October last year, and as well as Jack Ma's controversial speech in Shanghai was kind of the direct trigger. However, the underlying regulatory tensions have been there for a really long time.
Thank you, Angela. We might have an opportunity to go into that a little more toward the end of our session, when I hope we can get some comments from Steve and also perhaps some Q&A from the audience. Let me go quickly to our commissioner from the JFTC, Reiko. Please tell us what's going on in Japan. I know it's a different perspective on many of the same issues, the platform economy issues, all of the things that are really being looked at all over the world. So please, if you would.
Thank you for the opportunity to share the Japanese experience and also what's going. I hope to give you an idea, as Dad said, about what's going on in the Pacific region. So I'll talk about 2 things. One, how Japan's coping with the digital platforms, and then also about how the multinational groups that Jftc is engaged with. So first, the theme to digital platforms, I'll talk about 3 things: enforcement of the Anti-Monopoly Act, the advocacy activities, and the development of new rules regarding digital markets. And I'll talk about co-regulation, which is very interesting after what Angela said about the Chinese system. I think there's some similarities. First, about enforcement. There have been a number of cases in antitrust enforcement related to digital platforms in Japan, and the number is on the rise. We closed the investigation of Apple Inc. and its treatment of music streaming services in September last year. Apple required content developers to use only within app payments. When Apple proposed to take measures to allow developers to include an in-app link within reader apps, such as music streaming service, the Jftc recognized that the measure proposed by Apple would eliminate the suspected violation of the AMA, and decided to close the investigation after confirming that the measure had been taken. In Japanese competition law, there's concept of superior bargaining position, ASBP, which forbids a party who has superior bargaining position against other transacting party to make use of such position to impose disadvantage on the transacting party unjustly in light of normal business practices. The Jftc has applied ASBP to deal with the conduct of digital platforms whenever appropriate. Amazon Japan, a subsidiary of Amazon, was suspected of ASBP by unjustly demanding its suppliers to reduce prices or provide unjustifiable payments. And in September 2020, the Jftc resolved this case through the commitment procedure. Furthermore, when Rakuten, a Japanese operator of online retail platforms, forced merchants to apply a common free shipping threshold, the Jftc reviewed Rakuten's proposal to take voluntary measures and announced investigation closure after the Jftc confirmed the proposed measures had been taken. In the fast-changing digital sector, we believe that it is important not only to enforce measures, but also to obtain a commitment from the party to correct their conduct in order to restore the competitive environment properly and to change their business practices and business models, as in these cases. In addition, in order to address AMA in the digital sector, the JFTC revised its merger guidelines in December 2019, clarifying its approach to measure reviews based on the characteristics of digital services, such as the evaluation of data accumulation and consideration of indirect network effects. At the same time, in order to deal with the so-called killer acquisitions, the JFTC clarified the merger reviews and that it will conduct the cases when the acquisition amount is large, even if it does not meet the standards for pre-merger notification. And although the case of Google's acquisition of Fitbit did not meet the standards, the JFTC conducted a review under this policy and completed the review last year. In this way, the JFTC has been actively engaged in merger reviews in the digital sector. Now, advocacy. The JFTC has been conducting market studies in digital platforms and transactions. In October 2019, JFTC published a report regarding B2B transactions on online retail platforms and app stores. And in February last year, the JFTC published a report regarding digital advertising. Currently, we're conducting market studies on cloud services and mobile OS. The JFTC will continue to monitor status of transactions and identify potential competition issues and make known possible measures to be taken. And we think this is a very effective way of providing information, correcting questionable conduct. And last year, JFTC published a report on AI and competition policy for data market study group. The report, as it says, the report on competition policy for data market stated that it is desirable from competition policy point of view to promote open distribution and utilization of data. And for that purpose, it is necessary to ensure data portability and interoperability. Now, rulemaking, as a final note, I would like to explain the government's overall initiatives to develop new rules for the digital market. Headquarters for digital market competition was established in the cabinet in order to discuss the competition policy for the digital market, involving 3 ministries. And the act, the so-called Transparency Act, was enacted in 2020. The Transparency Act adopts the concept of co-regulation in which the Minister of Economic Trade and Industry designates large-scale digital platform operators and imposes on them the obligation to disclose information such as terms and conditions of transactions under the regulatory framework set by the government. The law also requires the operators to voluntarily establish procedures and systems for dispute resolution, which the government monitors. In addition, the Transparency Act authorizes the minister to request the JFTC to take appropriate measures under the AMA if it is found that a digital platform operator may be in violation of the AMA. Regulations under the Transparency Act are designed to solve problems in a way that does not inhibit innovation by involving many market participants. Transparency Act is expected to complement the AMA. The Act has been in effect for online malls and app stores since February last year. Amazon, Apple, Google, Yahoo, and Rakuten have been designated as operators to be regulated. Digital advertising sector will be added to the scope of regulation. Now, I'd like to say something briefly about the role of multinational groups. I would like to introduce the relationship between JFTC and multinational groups, such as the APEC and the ASEAN, and hope to give an idea of what's going on in the Asia. APEC, which is the framework for regional cooperation and sustainable development in the Asia-Pacific region, has established the Competition Policy and Law Group, CPLG, as one of its subordinate organizations to promote competition laws and policies in the region. Jftc is currently the vice chair and has been engaged in discussions and information exchange among competition authorities, promoting awareness of competition laws and providing technical assistance to developing countries in the region. The CPLG meeting is held once a year to report on competition policy of each member country, and workshops are also held to share the insights and experiences. At the CPLG meeting held last Friday, in fact, the Jftc reported its updates and developments of competition policy and made presentation on digital cases. The Jftc will continue to make significant contribution to the activities on competition and competition law and policy in APEC, strengthening the cooperation and collaboration with competition authorities in the Asia Pacific region. The Jftc, in collaboration with JICA and other bodies, has implemented the various forms of technical assistance to respond to requests by some emerging competition authorities, including ASEAN countries. For instance, Jftc, in cooperation with JICA, is currently holding a 2-week online training course for officials of competition authorities in developing countries, including ASEAN countries, explaining investigation procedures under the AMA review methods and international cooperation. Officials of ASEAN Secretariat joined these training courses as observers. The Jftc started the training course in 1994 in response to requests from developing countries, and this is the 27th course, and a total of 309 participants from 67 countries have participated so far. In addition, the Jftc has dispatched its officials as long-term experts to the competition authorities of Vietnam and Thailand in cooperation with JICA to help these authorities improve their capacities to enforce the competition law and design competition policy. An office for the dispatched official has been set up in each competition authority, and they're stationed there to provide support while directly engaging in the work of host authorities. Furthermore, since September 2016, the Jftc has been providing technical assistance to the competition authorities of ASEAN countries throughout Japan, ASEAN integrated through JIFE, which is a fund established in the ASEAN Secretariat based on contribution from the Japanese government to strengthen the enforcement of competition laws in these countries. In this project, in addition to providing training courses and seminars, Jftc conducts joint research on dissemination and awareness raising competition law in the region. I think that these initiatives contribute to building, strengthening relationships and mutual understanding, as well as optimizing law enforcement in the ASEAN countries. Thank you for your patience.
Thank you very much, Reiko. That was you and Angela have both put a spectacular amount of information in front of our audience in a very short period of time. So thank you very much for that. I really did not have any idea that the JFTC's multinational efforts and the cooperation with the multinational organizations had been as extensive as it sounds like they are. Shifting gears slightly, Fei, we've asked you to comment on a slightly broader perspective about, one of the manifestations of the influence of digital platforms and other developments in the United States has been a kind of a two-level attack on antitrust as we currently know it. In one respect, the attacks are on the entire conception of a consumer welfare-based, economics-based approach to antitrust. And on the other hand, there is an attack on the practices of digital platforms that at times almost seems to suggest that what we are going to do is leave antitrust alone, but have a kind of a supervening regulatory system for these particular, giant, so-called giant digital platforms. And sometimes the two get very confused. So I would like you, if you don't mind, to comment on, the major trends in the Asian jurisdictions, and tell us how this is influencing and likely to work out in Asia, and perhaps comment on, contrast it to what's happening in the United States and Europe, if you're so inclined.
Sure. Thank you for the question, Ted. Hi, everyone. My name is Fei Deng. I'm an economist at CRA. Although home based in California, most of my work involves advising companies dealing with antitrust and IP issues in China. And some of these companies are domestic Chinese companies, and some are non-Chinese companies. Some are digital platforms, some are non-digital platforms. I've also worked on both sides of the table. I've been engaged by China's antitrust agency as their outside economist in a number of cases over the years. So the question raised by Ted, although it's originated from the platform discussion, but I understand it's wider than that, which is perhaps regarding the welfare standard of the antitrust law. And clearly what's happening in China in terms of the regulatory crackdown on the digital platform is not just driven by the computation concerns. There is a public policy angle to that. And that's why, we have seen the many digital, pretty big digital platforms expanding over the years in China, but nothing happened until pretty much last year, 2021, when the antitrust agency suddenly cracked down on this industry. So this raises the question, perhaps the wider question, which is, what is really the enforcement standard of the Chinese antitrust law? Well, honestly, I got asked by a lot of people on this question from both sides of the Pacific Ocean. Although things are changing in the US, I don't think things have changed much in China on this particular issue. Oftentimes the antitrust community in the US will question whether there is any concrete or objective standard used in China in antitrust enforcement in any industry, not just digital platform. And folks in China are also curious about why the US set consumer standard as a single standard. And more recently, folks in China have been surprised by the movement in the US to change the standard, and are wondering whether maybe the US is finally going to agree with China and converge with China on this issue. So back to the bigger or more general question, what is the welfare standard of China's antitrust enforcement? Well, since China has a stable law system, to answer this question, we would start with a close look at China's antitrust law itself. Article 1 of the Chinese antitrust law identifies multiple objectives, including enhancing economic efficiency, safeguarding the interests of consumers and the public interest, and promoting the healthy development of the socialist market economy. I know that's a long term, but let's break it down a little bit. So this law was adopted since 2007. And you can see the law itself was never meant to protect just consumer welfare. And the recent amendment, as mentioned by Angela, is there is a recent amendment to China's antitrust law, which is expected to take effect later this year. And that amendment has added one more objective, which is to encourage innovation. So this objective is added and listed before all the other objectives that I just mentioned. And I would like the audience to pay attention to the order in which each of these objectives are listed, because the order here does matter. Actually, the later listed ones are more important than the ones listed in earlier in this paragraph. What does that mean? That means the last objective, which is to promote the healthy development of China's economy, is the ultimate and the most important objective of China's antitrust law. And the objective of safeguarding public interest is also more important than the objective safeguarding consumer welfare in China. So the lesser importance placed on consumer welfare in China is perhaps not surprising, because China has always believed the government and the companies are much more central to the country's success than the consumers. So as you can imagine, what could potentially facilitate the healthy development of China's economy, or whatever falls under the public interest, may include various non-competition factors, including industrial policies, as well as other considerations as well. And the exact types and emphasis of such public policy considerations may evolve over time, as you have observed from the digital platform industry. So in summary, the generality and the ambiguity of the objectives listed in China's antitrust law leaves a lot of room for the antitrust authority to interpret and execute. So now I'm going to talk about, in practice, when and how do China's antitrust authorities take account of this public policy considerations in the enforcement. While you have seen the example of digital platform, but also that's obvious in other aspects. For example, in terms of administrative enforcement, China's antitrust agency would solicit information and opinions from other government administrative agencies, which is a well-known fact stated in many of the published merger enforcement decisions of China's antitrust agency. So that's a pretty obvious fact there. But it's a less obvious, more subtle aspect lies in the likelihood of consideration of public policy factors by the antitrust enforcers in potentially every single case. And this is perhaps best illustrated by the China's antitrust enforcers' own words. There was actually a public speech made by a highly respected Supreme People's Court judge back in 2017. Although the speech was made in 2017, I think it's still valid. The speech, it was titled Antitrust Enforcement Under the Backdrop of Innovation and the Digital Economy. And the speech started with remarks that emphasized computation considerations and economic analysis. I'm going to read the judge's own words, just translated from Chinese to English. So the judge said, antitrust law enforcers and the judiciary should be adept at using economics to think about issues. Efficiencies and effect-based analysis should be placed at a priority. So those are all traditional computation concerns, which is great. However, the speech followed with a long discussion on policy considerations. Quote, law enforcers and the judiciary should also pay attention to policy thinking and combine legal judgments with economic analysis. The mainstream view of American anti-monopoly scholars holds that the policy factors considered by the EU competition law and China's anti-monopoly law are inappropriate. And there is only one competition law standard, which is consumer welfare standard. I don't agree with this. Whether admitted or not, policy thinking lies deep in the heart of law enforcers and the judiciary. We know that when there are multiple legal application methods or multiple likely outcome choices in a case, law enforcement officials would carefully consider and weigh the impact of different applicable results on society and the market. At those occasions, policy thinking will play a role. We must strive to make the results of our own judgments consistent with legislative objectives, in line with the spirit of legislation, and in line with national industrial development. This involves the consideration and balance of the long-term interest of the country and the short-term interest. I think this is a question that judges cannot escape. We need to consider what the national policy is and what China needs. End of the quote. So these statements describe quite well how deeply entrenched the policy notion is for China's antitrust enforcers and the potential for it to affect every single case. So this leads to, very quickly, my last point regarding, as practitioners, what can we do when advising clients in antitrust matters in China? Should we just give up? Well, what we can do is try to change China's antitrust law standard, or try to convince China's antitrust enforcers that the consumer welfare should be the single standard. And there shouldn't be any policy consideration at all, because that would go nowhere. But what we can do in practice is to think of ways that we can take account of the multiple objectives of China's antitrust law, with the ultimate goal being promoting the healthy development of China's economy. And portray your client story in a convincing way that would appeal to the enforcers. This is especially important when advising non-Chinese companies against claims brought by a domestic player, for example. To give you just an example, assuming the alleged merger or the alleged conduct will in fact harm a particular domestic Chinese competitor who complained to the antitrust agency, then the type of arguments and analysis that could potentially help your case, other than analyzing the effect on the consumer welfare and analyzing whether the complainant was indeed harmed, or, for example, to analyze the effect of the merger or the alleged conduct on the welfare of other domestic companies, whether those companies are competitors or downstream or upstream to your client. Also, you could analyze how the entire industry in China could be affected in the long run. So those are the types of arguments that practitioners can structure concrete economic analysis to address, whether empirical or theoretical, that I've found to be effective in the past. And perhaps Steve or others have other good suggestions as well. Back to you, Ted. Thank you.
Oh, thank you so much, Fei. That's, again, a superb presentation, packing a tremendous amount of great information into a very efficient presentation. I appreciate it. So, Steve, as promised, the field is yours. You're one of those rare types who has been right in the middle of major antitrust proceedings in virtually every significant antitrust system in the world, in Europe and the United States and in China and Japan and other jurisdictions in Asia. Very interested to hear your commentary on any of this, or even if you'd like to pose questions to the other panelists, feel free.
Thank you, Tad. Well, all of the panelists till now have really intrigued me with their comments, and I think China and Japan are two jurisdictions I have focused on in the last decades of my career, and I find the developments in both current developments in both fascinating. So let me say this. And second, I don't claim to be an expert in either of them, and we have real experts. So, but I can tell you as a practitioner and a person who tries to do what Fei just said, which is to present a company's particular issue in a way, hopefully, that an enforcement agency or a court would see as pro-competitive or consistent with the aims of the applicable law. It concerns me, purely as a practitioner, it always has concerned me, the breadth of the Article 1 purposes clause. This is not new, as Fei said, as Angela knows, as we all know, this is clearly a statement that's consistent with many other Chinese statutes. It's consistent with the Chinese Constitution. It's not surprising that one would see this language. I have been pleasantly surprised. It's been a lot of years now since the AML went into effect, so I'm no longer surprised. But I was early on happily surprised that in almost every case, these more vague concepts of public policy or promoting the development of the socialist market economy have not really played a specific role. While I'm sure they are they're always in the minds of the enforcers, they're always in the minds of the agency personnel and the court personnel, that a decision under the anti-monopoly law should certainly not be inconsistent with either of those policies. It has heartened me that the decisions, at least the ones I've been involved with, cases that generated, have focused on, and I may disagree with how they focused on them, but they have focused on the economic science and the legal principles of competitive harm, competitive injury that are familiar to me as an American practitioner, and very rarely, I think, have significantly been based on these more broad, wide-ranging policy considerations. I like that as a practitioner because it's easier to advise clients, and clients don't want to know what I think the socialist market economy should look like in China. First of all, I don't know anything about it. Second, the subject is, in my mind anyway, so vague as to not give businesses much usable guidance in terms of deciding what course of action to take before they are called upon by an agency or questioned by a court on their activities. So with that background and with Fei's very helpful explanation that of the importance of the order in which these are listed and the new one of encouraging innovation, which I guess, given what she said, is the least importance of these, but clearly it has importance because they took the time and energy to include it. I would like to ask how she thinks about these in the context of a particular case that comes to her when she is faced with trying to frame the presentation and demonstrate do you take into account, for example, at all in a specific way, either of those last two categories of considerations under Article 1? Or do you focus the analysis on the sort of hard economics and consumer welfare-based analysis that we're all familiar with, while you may highlight that, you know, this is good for the consumer, it's also good for the development of this industry. But do you ever go beyond the industry to talk about the economy? Do you ever get into macroeconomic considerations, for example?
Yeah, that's a great question, Steve. Without revealing privileged information, but there's no short answer. Let's start with on all of the cases I worked for the Chinese Antitrust Agency as their outside economists, I've never been told to use any different standard or any standard at all. We don't talk about a standard. It's kind of by default. You do your economic analysis the way that you think is appropriate. And I worked with the Chinese Antitrust Agency in their investigation of, you know, both Chinese companies and also non-Chinese companies. There is never any difference. I've never been told what I should do, or I should give a particular outcome to the agency. And of course, when I perform my economic analysis, it's really based on just the evidence, the data, and, you know, what's basically the expected increase in price or other issues, which are very typical in the US. So nothing really different. In some of the cases that I work for companies, especially non-Chinese company, I've been advised by the legal counsel to really take account of the effect of the merger or the conduct on certain Chinese companies. Then you just do your analysis. You know, those are concrete analysis you can do to really address those questions. And in certain other matters, I've been asked by legal counsel to analyze the effect of the conduct on the entire industry as well. And that's those cases are both for Chinese companies and for non-Chinese companies. So those concrete analyses definitely appear really a case-by-case difference. But in the end, it's all computation concerns, I would say, not really public or non-computation concerns per se.
Thank you. That's very helpful. And turning to Japan, I followed the Rakuten case, and I was wondering, Aoki Sensei, if you can tell me your thoughts on this case that basically ended in a fairly quiet way, which is somewhat typical of a lot of major Japanese cases, and the concept of administrative guidance, as we call it, as we translate it from the Japanese, is quite foreign to American law, and Americans like to fight, and Japanese like to make peace. So you have a much better system and than ours. But the result was, as I understand it, sort of agreed upon notification process, which to my thinking, I can't remember another case in international antitrust that's been resolved in this way, where basically a company that thinks the policy might harm it, and it wants an exemption from the platform's free shipping. This is all about free shipping in a digital platform, and the harm that may do competitively to brick and mortar installations. It's very creative, and I was wondering if you can explain that, explain how it came about. Was it Rakuten itself that came up with this? Was it the JFTC or both? And do you, you must see this as workable. Otherwise the JFTC would not have imposed it, but how much monitoring is required, I guess, to see if they are in fact granting exemptions on what, on an ongoing basis, you would say is a fair and pro-competitive manner?
Thanks, Steve, for pointing out a very interesting case. And actually, you're right. It's a typical Japanese case, I think. This is my personal opinion. But it hasn't finished, actually. Officially, the case is still open. And JFTC is still keeping watch. We have our eyes and ears open. A lot of these abuse cases come from complaints from the merchants that are getting hurt. And our ears are still open to what they're saying. And the way, as you said, Rakuten didn't believe in, really didn't believe what it was doing was hurting anybody, that it was just part of the normal business activity. And they refused to, this is my opinion, they refused to listen to what we were saying. I mentioned all these reports that we publish where we point out what the problem should be. And this is very close to administrative guidance kind of approach. And they'll read this and they'll voluntarily correct what they're doing. In case of Rakuten, they refused to do that. And they went to the newspaper and said, we're not listening, basically. And so JFTC actually went to court to stop them. And then Rakuten fought. So it was very American in that respect. We went to court and then Rakuten responded and said, oh, okay, they changed their behavior. So we withdrew the court case. So, and it kind of looked like closure, but the case has not closed.
The court case is closed, but not the JFTC case.
Yeah, we withdrew the court, but the abuse case is still open. Since JFTC is not really a regulator, it's not an ex ante regulator, right? So administrative guidance is not the term that should be used for what we do. But you're right, a lot of competition enforcement, now that you pointed out, has a very similar administrative guidance flavor to it. So I mentioned commitment, but besides commitment, we're very happy with commitment because it's very quick and it does the job. And in case of surcharge, the money goes to the government. But with commitments, the firms would pay back whoever was hurt. So that, and in Japan, it's very unusual to have private litigation to recover your losses. So through the commitment procedure, we're actually able to give aid. I mean,
yes.
Give payment to the people that pay for the damages, make them pay for damage. So
are they required to notify you when one of these exemptions is requested?
What do you mean by it?
Does Rakuten have to notify you that company X requested an exemption from this free shipping policy and either they granted the exemption or they did not grant the exemption? Does Rakuten have to keep JFTC informed of these requests under this guidance? No. Okay. So I guess if the company was refused, they could complain to you. So that's how you would.
That's the way it works. Yes.
Okay.
Because the case is still open.
I understand.
Steve, we're coming up on our closing time, and we've actually got a couple of questions. One is China focused, and the other is Japan focused. So if you don't mind, I'd like to go to the two questions, and since you're familiar with both regimes, if you want to join in responding, please feel free. But
oh my gosh, but we've got better responders here. Go ahead, Ted.
Be that as it may. question number one, this is the China-focused question. Does the operation of state-owned enterprises in China add subtleties or complications to antitrust in China that an American attorney or economist might not be familiar with?
Yes, that's the answer to that question. This is a very important question, one that there has been disagreement about since the early drafting meetings of the AML, of which I attended some of. And the professors who disagree on this subject still disagree on the subject, from what I can tell from what they're writing and what I hear. So it is open to interpretation, let's say, as to whether the SOEs are treated specially under the AML. As a procedural matter, they are, and we can go into, it's probably not, we don't have time anyway, but there is a particular procedure under which they would be basically regulated by their own sectoral regulator, not by the competition regulator under the statute. But how that works exactly in practice differs case to case, at least in my experience. And the SAMR and its predecessor agencies took, at least the predecessor agencies between themselves, between SAIC and NDRC, took different views on this issue in certain cases. So it is, as far as I know, still an issue fraught with uncertainty, extremely important issue because of the importance of SOEs to the Chinese economy and the market power of certain of the SOEs. But I would ask either Angela or Fei to jump in if they want to add more expert views on that, but that's my answer.
Fei, would you like to give a quick response?
Sure, I agree with Steve, and I just want to mention that actually in preparing this webinar, I actually saw an article just published last year or 2 years ago by some scholars investigating specifically on the enforcement of antitrust law on the state-owned enterprises in China. I can dig that up to send whoever asked that question, but there are articles out there summarizing this issue.
All right, let me conclude with a very brief and specific question for Reiko. It's about the Jftc case involving Amazon. And the question is, did Amazon argue that the terms it sought from vendors would be passed on to consumers in the form of lower prices? And if it made that argument, would the JFT consider that as a defense to any antitrust challenge to those terms?
Yeah, I can answer the latter question. So yes, that would be considered if that kind of argument was made.
All right, great. Well, we finally found an Asian antitrust question with an easy answer. Thank you very much. And I think we're at our closing time, so I think I'll bring this to an end. Thanks very much to the panel again for a fascinating and information-packed, very efficient presentation. Thank you to all. That concludes the session. Please return at noon Eastern Standard Time tomorrow for our next session, which is called Competition from the Perspective of State Attorneys General. We look forward to you joining us for programming that will continue throughout this week. Thanks very much. And again, thanks very much to the panel.
Thank you, Tad.